think we've got a quorum. We'll go forward with the meeting. This is the Thursday meeting of the House Judiciary Committee. We're starting a little early so to get everybody, we hope, back home before it's too dark, too late. I'm called for the first bill, which will be Senate Bill 179, and that bill is the Senator Hill's bill, but he is not present, I think, and you want to go ahead and present that bill, if you can do it from your seat.
Yes, sir.
Pull your mic around.
Thank you, Mr. Chairman. Senate Bill 179, which was passed out of the Powell Subcommittee, or was it Jacob Subcommittee?
179 was Powell.
Powell Subcommittee on Monday. And it is, in its present form, a combination of two bills. First off is Senate Bill 179, which was passed out of the Senate. And basically what it does is it clarifies when bonds are necessary in bid contracts. When bonds are necessary in public contracts by bidders on those particular contracts. It basically lays out that that bonds will not be required in every instance, but will only be required in those particular instances in which, as part of the original request for bids, it mandates that bonds will be required. It also sets out a program by which the local government can, in its contract with bidders, impose both penalties and rewards for completion of work. Obviously, if work is completed early, this bill will allow incentives to be given to contractors for finishing the work early. If work is delayed by fault of the contractor, it allows for penalties to be imposed. It doesn't mandate either of those, but simply sets out clearly that under Georgia law, such provisions are permissible when it comes to public contracts. In addition to that portion of the bill, which was the portion that was passed out of the Senate, we have, beginning at Section 4 of the bill, inserted House Bill 362, which deals with the right to work principle under Georgia law. That has already passed out overwhelmingly from the House. What this essentially does, for those of y'all who recall the floor debate, is simply mandate that neither the state nor any local government can mandate from a bidder that they must use union labor. Of course, union labor can be used on any public contract, and on many public contracts, it will be used. It simply does not allow for bidders utilizing union contracts to have any kind of leg up over bidders who do not utilize union labor. That's all it does. It's the exact same bill that we passed out of the House verbatim. Okay. That's essentially the bill, Mr. Chairman.
Thank you. Any questions of members of the committee or the presenter? Is there anyone who would like to address the committee? You have a question? Is that Ms. Stevenson?
Thank you, Mr. Chair. And to the presenter,
yes.
I understand that you have added another code section. And there are two different code sections, am I correct? What LC are you working on?
LC 295636 ERS.
36. Wait a minute. Is it under?
You're talking about the addition of
Section 5?
Yeah, beginning at, yes.
One portion, Title 13, is contracts, and Title 36 is local government, correct?
Yes.
Right. And
They both portions all deal with public contracts. That's the similarity in the bill.
well, they both deal with bidding. One deals with it in local government. What is your opinion on the germaneness of Title 36?
I don't think you can ask the presenter about germaneness. You
Well,
can ask me about it.
Okay. Well, may I ask him a question?
Yes,
Or
ma'am.
reword it? How do you, not germaneness, how do you think the amended portion flows with the 1310.3?
I believe it flows perfectly with it because they both deal with how individuals either companies or individuals who choose to bid on public contracts will be treated by either local or state government.
Okay. So you didn't want to put it under Title 13?
I believe what I wish to do was simply continue back to the floor of the House a bill that is exactly the same bill that we've already previously passed, so that the House desire to have HB 362 be taken up by the Senate.
Okay. Thank you to the author. And my germaneness I will reserve to ask the chair.
Any other questions of the committee to the presenter? If not, we will ask for any other members of the public wish to speak to the committee. Yes, sir.
Chairman, I would.
Please come up. Please come up and let us have you sit down with one of the chairs here with the mic, and please introduce yourself and who you represent. You pull that down. That's good.
My name is Keith Thomas. I represent the building trades here for the Atlanta North Georgia area, representing a little over 600 contractors and pretty close to 25,000 members. I just had a question here on this. I know a lot of this is volunteer, but if you look in one section there where I have an issue sort of discriminates.
Bring it to our attention.
It's starts
Line
off on A,
line
page
number,
2. Mm-hmm.
Page 2,
Line A.
line. What's the line number of the?
I just have line A, page 2 of this that was handed out.
We have
Well,
on the
wait,
side.
I'll start off with.
We have the
and read
side
it.
column here. Some
Oh,
numbers.
sorry, sir.
Those are-
51.
51. Okay.
Yes, sir. I was
State your
more
question.
focused on A.
I know.
Require prohibit bidders of contractors, subcontractors, and material suppliers to enter into a HERE or pre-hire agreement, project labor agreements, collective bargaining agreements, or any other agreement with one or more labor organizations on the same or other related construction project. In my personal opinion here is that when you say that they can't enter into one or more labor organizations on the same project, you would not be able to utilize a project labor agreement because most projects are from ground up, and that would utilize at least 14 different crafts.
That is correct. You're not going to be able to have as part of a bid contract imposed by the state or local government that gives any kind of preference to bidders that utilize as part of their bid union contracts or union labor. It allows for it simply if you wish to enter into it, but it simply doesn't allow the state or the local government to mandate it.
Well, shouldn't local governments decide on which direction they want to use their tools?
No, sir. This is basically, we have a long-standing principle in this state of right to work, and we should not allow any governmental entity in this state to discriminate against non-union labor in variance of a long-standing public policy in this state in favor of right to work.
There's no discrimination on right to work. I would agree with you on that. Nobody's discriminating against them. Under a project labor agreement, a contractor can choose to bid it or not to bid it. All the PLA does is set the terms and conditions for that project.
What's PLA?
PLA is a project labor agreement. We don't utilize a lot of those here in the state of Georgia. One of our biggest, I guess, owners that we work with is Georgia Power. And Georgia Power utilizes them with labor because it gives them a way to guarantee their workforce and predict their costs going forward.
And Georgia Power can continue to do so as a private entity.
Correct.
What this simply does not allow,
Use your mic.
thank you, what this simply does not allow is any type of government of this state, whether it be local or state, to act in variance of Georgia's longstanding public policy regarding right to work. That's all the thing this does.
Well,
Let me mention-
yes, sir.
I understand. It would not affect what you described, though, either as Georgia Power. This is not one that affects Georgia Power. It only deals with public entities.
Well, where I was going with Georgia Power, it seems to me that if Georgia Power sees value, and we see Georgia Power as one of our best entities in this state, providing good service at a low cost, why would you want to tie the hands of local authorities in maybe utilizing this same tool by restricting one or more?
It may be that your question would not. We'd rather have you make statements as opposed to questioning members of the committee. So if you're here to give testimony, that's what we would like to hear from you.
I apologize.
And no problem.
And what I'm saying is that if Georgia Power, in my statement, sees value, 70% or more of their workforce is unionized, they utilize these agreements going all the way back to the 70s. Why would we want to restrict anybody else from utilizing and learning about a project labor agreement where it may benefit us all as taxpayers? I'm a taxpayer, and I think I should have say-so if a project wants to be utilized under PLA. I should be able to utilize that as well.
Appreciate it.
Thank you.
Questions of the witness? Did you want to ask something, Mr. Fleming?
If the shoe were on the other foot, and we were passing a bill that says that no local government could use union contracts, you wouldn't be in favor of that, would you?
No, sir, in this one either.
But you are in favor of local governments being able to say it has to be a union contract.
I am in favor of local governments. Historically, in a right-to-work state, they've chose how they do business. I don't think we should put something together that limits a local authority on how they do business when it's never even been used. Leave it alone. If we've not had an issue with it before, let each entity, and from a taxpayer standpoint, let them decide.
So if a local government said we are not going to allow any union shops to bid on our projects, you would support that?
I can't tell a local authority to use a PLA or not to use one.
Yeah, but that was not my
They're going to do that in their
question.
bid document.
My question was, if a local government said no union shops can bid on this, would you support that?
I would not support that.
Okay, my point. Thank you.
Okay. Any other questions of the witness? Ms. Oliver, thank you.
Do you have a good number of how many of the 159 counties and 500 cities this is going to impact?
Well, I guess the best way for me to try to answer that is I think the group that is pushing this, if you look at their website, it's ABC, they have 300 companies, suppliers that they represent. If you look at this book here, I took this and I counted out 300 companies and suppliers which make up this much of this book.
That book, tell us what that book.
This book is a blue book. It's on building construction.
Okay.
So why would you look at an organization who represents this when the rest of the state, under the right to work state, has been utilizing and doing how they want to do business, which is based on this number of people? I don't see giving any special interest group a deal. I'm not here today asking, Ms. Oliver, for every project to be built union. I'm not doing that. Let us do business how we've been doing business. And that's all I'm asking.
Anything further, Ms. Oliver?
No, Mr. Chairman.
Thank you. Thank you, sir.
Thank you,
Appreciate
Chair.
your speaking
Thank
with
you,
us.
sir.
If there's no one else who wishes to speak to the committee, we will close off further public comment on this bill. Any discussion among committee members? If not, the chair will end. There's discussion. Hold on. Ms. Jones?
Sorry, and please excuse me for being late, Chair, and I'm sure that the author of the bill explained this. I guess I'm not familiar with this area very well, but it's of area of law. But the new sections of this bill prohibit anyone who or any local government from entering into a contract if there are union employees. Is that correct?
No.
Okay, help me
This is
understand.
Exactly, if I may, Mr. Chairman.
Yes.
This is exactly the bill that we passed previously in the House, HB 362. All it simply does is it bars any local government or state government from mandating the use of union labor as part of a bid. It doesn't prohibit construction companies that utilize union labor from bidding. It simply just bans the state or local government from mandating that union labor be used. That's all it does.
All right. Yes, sir. Mr. Bruce?
Very quick question to my colleague. Why would we ban that as opposed to, if I keep hearing this whole session about local control. So if a local government wants to do that, why would we stop them?
Once again, we've already been through this on the floor of the House. I'm happy to go through it again. What we have in the state of Georgia is a long-standing principle of right to work. That is a principle that has stood this state well for well over a half a century. What we're simply doing is making sure that that long-standing public policy, state public policy, is not deviated from by either the state or local governments through the back door, where they're not permitted to do through the front door. That's all the bill does, sir.
All right. No further comments. The chair will entertain motion.
Move to pass, Mr. Chair.
Moved and seconded. They do pass. Is there discussion on the motion? Is there any amendments? There being none, the chair will call the main question, which is do pass Senate Bill 179 as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. No. Chair rules the ayes carry it. Bill is recommended do pass.
Thank you, Mr. Chairman.
Call his next.
He's not here. June takes it.
Okay. Let me call Senate Bill 168, a bill by Senator Tippins, who's not here, but you're going to present it, as I understand, Ms. Jacobs.
Thank you, Mr. Chairman. Senate Bill 168 in Sections 2 and 3 of the bill enables contractors who may not have performed work that is as great in scope or cost as the project that is under consideration by a governmental entity, whether it be state or local. State, of course, being what you have in Section 2 and Title 13, and local being what you have in Section 3 and Title 36. But nevertheless has performed work of that kind. To give them, if there is not more than a 30% variance in the size or cost of the project, to enable them to be considered as a bidder on that particular project. It does not give them any kind of preference. It just simply allows them to be considered for that particular project. That is the underlying proposition that came over to us from the Senate. In addition, you have some additional sections that were added in subcommittee related to MARTA. These were part of House Bill 264, which passed the House significantly prior to crossover day. They are in Section 4 of the bill, a 3-year lift of the 50-50 split through 2016. Right now it is scheduled to expire in the middle of this year, June 2013. The revisions to the Board of Directors of MARTA in Section 5 of the bill. In Section 6 of the bill, we have the requirement that the recommendations of the KPMG audit with regard to privatization be carried out within 5 years. And also in Section 6, the second code section, the debt ceiling provision that requires MARTA to step down its bonded debt to 40% after 3 years and 35% after 6 years from the present 42 to 43%. Mr. Chairman, that is the bill, and I will be happy to answer any questions.
Any questions by members of the committee of the presenter? All right. Is there anyone? You got to be quick. Ms. Stevenson?
Thank you, Mr. Chair. To the presenter, first, Section 6. Well, by way it went to the Senate, were these sections, you said they all were added in the committee, all of the MARTA?
No, as you'll recall, the bill that passed the House were revisions to the MARTA Act. And those were much more extensive revisions to the MARTA Act that also dealt with some reporting requirements and collective bargaining and things like that. These are all general code sections, so we're not dealing with all of that in this bill. It's only certain provisions that were in that bill.
My question is that are the provisions in this bill that were in House Bill 264, were they added in committee or were any added in the Senate?
Any changes?
Yes.
No, they were added in subcommittee. Representative Stevenson.
Ms. Jones?
And this is a freshman question because this apparently happened before I got here. I noticed that the body, and I'm looking at Section 5 on lines 99. Why do we have one member appointed from the board that's south of the city and two from north of the city of Atlanta coming from Fulton?
That's a function of population, Representative Jones, and it is actually in current law that there are two members from south of the city of Atlanta, and I'm sorry, two members from north of the city of Atlanta and one member from south, and it's simply at the time that that was enacted, which was the old House Bill 277, the Transportation Investment Act, when that was done, it was a function of the fact that there are twice as many citizens living north of city of Atlanta than south.
And have we looked at that since the new census?
Yes, that's as of the new census, and I double checked that as well. That specific point when we put together House Bill 264.
All right, Senator Liggins, I saw you. Saw you come in. This is your bill. Do you want to address the committee on your bill?
Where?
No. I'm sorry, it looked like Tippin. I'll pay your part. You look like Tippin standing there. My mistake. I know you look. What the hell am I looking at? He didn't look like it.
Kind of.
Both of you have mustache anyway. All right, back to business. Anyone else want to address the committee on Senate Bill 168? Includes Senator Tippins. All right. If not, we'll close off further public input. The bill is down to the rest of the committee. And Mr. Fleming?
I'm going to ask a question of the author at the appropriate time, Mr. Chairman.
You may.
And I know the senator's not here to talk about the underlying bill, which is his portion. Are you okay with me asking you a question about that?
Sure. I'll try to answer it based on what
I assume we're trying to solve a problem that exists with the underlying bill. Is that correct?
I believe that to be correct. I mean, what Senator Tippins and others, I mean, there's a good group of co-sponsors of this particular legislation over in the Senate, are looking to happen is for smaller contractors who obviously would like to get a leg up to be bigger contractors, growing small businesses. To have that opportunity if they're competent in doing the sort of work that is being called for in the request for proposals.
My suspicion is that one way the local government decided if someone was confident to see if you'd ever done a job this big before. But and obviously it has a limitation on here. It's a 30% number that you have to come within 30% of having done a job that big. Is there? And I assume that somebody's looked out there and said, we got a lot of companies that are just being X'd out before they even start. And even though they've come kind of close to doing a job this big, and we're trying to eliminate that from happening automatically. Is that what we're doing?
I think that is the intent of the bill. And certainly, obviously, there are others in the audience perhaps who could speak to, how this has worked in the real world. But that's my understanding of the intent of the bill.
And I assume that since ACCG or GMA is not here opposing this, that they have taken at least a neutral position
They-
on. Is that fair
They
to say?
spoke at subcommittee.
They spoke at subcommittee, and that they were okay with it.
Generally.
They expressed some concerns, but we accommodated some of the concerns, I believe, is a fair statement.
Okay, thank you.
Thank you. Any further discussion among committee members? If not, we will entertain motion. Motions do pass.
Second.
Is seconded. Any further discussion? Are there any amendments to be offered? There being none, the chair will call the main question, which is due pass to Senate Bill 168 as a committee substitute. All in favor, signify by saying aye.
Aye.
Opposed, like sign. Chair rules the ayes have it. Do pass. Next we'll do is 113, because I've got Senator Jones. We do have a senator here, finally. Come around, please.
That is Senator Jones.
I won't make the mistake twice, Senator.
He does have a mustache.
All right. Thank you, Senator Jones. You're here to present your bill, Senate Bill 113. Please tell us about it.
Yes, thank you, Mr. Chairman and members of this committee. This is a bill that has been vetted with the Chamber of Commerce, National Federation of Independent Businesses, the trial lawyers, and vetted with the Secretary of State, and I believe that's right.
All right.
At the chair of the Judiciary. And I certainly appreciate this committee, the subcommittee, for their hard work on really perfecting this bill and making it much better. It is a business-friendly bill. What Senate Bill 113 does is that it changes the code section relating to personal service on corporations. It deletes secretary and cashier. Back on line 14 for corporations domesticated and incorporated in the great state of Georgia. And over on the second page, on line 37, it gives a definition for managing agent that I believe this committee has perfected. Starting on line 41, it talks about actions against a non-resident individual. Foreign corporation was deleted in that code section. And it also gives a definition for managing agent as it pertains to those corporations and non-resident individuals and partnerships and joint stock companies as well. The origin of this bill is due to the ambiguity related to cashiers and secretary. And I know in my business I've had several events where people within my business were served that probably shouldn't have been. This is a bill that I've been working on for 2 years, and I would certainly ask the committee for their favorable consideration for Senate Bill 113.
Thank you very much. Appreciate you presenting it to us and bringing it to the committee's attention. Any questions of Senator Jones by members of the committee? If not, I know there's someone else who would like to speak on the bill. We have Mr. Bill Clark with the Georgia Trial Lawyers Association. If you'd like to come up, and you can keep your seat, like we'll put him next seat over to you, and turn on that mic also.
Good afternoon, Mr. Chairman, members of the committee. Bill Clark on behalf of the Georgia Trial Lawyers Association. We just wanted to take the opportunity to thank Senator Jones and the Chamber of Commerce and Chairman Willard for allowing us to participate in this discussion. We believe this bill appropriately streamlines the service of process so that plaintiffs can appropriately serve defendants and defendants can appropriately be served when lawsuits are filed. We greatly thank the Chair for your work in perfecting the language that, frankly, Senator Jones and the Chamber and we struggled with for about a year and a half, or for more than a year anyway. And we believe adding the definition of managing agent, as you have, solves the problems that the current law has. We get rid of the arcane language of secretary and cashier, and we support the bill and appreciate the help you've all given us, and I'm glad to answer any questions if there are any.
Appreciate your comments. Any questions by members of committees of Mr. Clark? If not, we will
That's a mistake, right?
close off
This will be
that part. Anyone else wish to speak to the committee on Senate Bill 113? If not, we will close off further public input. The bill is now on the breast of the committee. Is there any discussion among committee members? I'd like to take a personal privilege for a minute just to give you some background, because going back a year earlier, though, we had the garnishment bill, which I spoke of at the subcommittee. We took out the language in there that's very similar about the secretary or cashier being served in garnishments, because, again, it was confusing there. And we really just referred service to OCGA 911.4, which covers everything as far as service. This is older language, and we felt that it was good to remove secretary cashier as you're doing in your bill. And what we really have done is divided up on the service of corporations and businesses. Section E1 deals with corporations, both domestic corporations and foreign corporations. And then we have Section 2 really deals with what we'll call other forms of business, whether it be an individual proprietorship, partnership, joint stock companies, or association doing business in the state. And we've also, I think, recognized that you could have a foreign corporation which is doing business here but not actually registered to do business, and so there's a form of service that can be made under those circumstances. Or if a corporation, domestic or foreign, has let their registered agent lapse, you have ways of getting still service on that entity. So I think what we've got here is a logical progression for the service when you're looking at serving businesses, and that was what we did, was try to clarify what a managing agent means under either circumstance as far as a type of business operation. And that's where the language came up with Section 1B and 2B. So that's just a comment I want to make about it, and I think it's a good progression for us. Any other comments from the members of the committee? If not, I will entertain a motion. Move, do pass, and second. Are there any amendments to be offered? If there are no amendments, the chair will call for the main question, which is do pass to Senate Bill 113 as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you. Thank you,
Mr.
Senator.
Chair, member of the committee, and
Who you going to be having that sponsored on the floor?
if I may just leave that to the discretion of yourself, Mr. Chair.
Okay, we'll get somebody sponsor for you. Maybe Mr. Welch or Mr. Fleming. Mr. Fleming, you haven't had much up this year. You want to take a shot at it? We'll get
Thank
taken
you.
care of for you.
Thank you, sir.
Yeah. I'm going to turn the further presentation. I'm going to call for House Resolution 644 and turn that over to Mr. Jacobs to chair. This is my resolution.
All right, we'll go ahead and call up House Resolution 644, and I'll recognize Chairman Willard to present the resolution.
Thank you. A few years back, I helped working with a group dealing with the issues regarding forestry in this state, of all things. I'm not by any means a forester, don't deal with that, but the concern in question was there has been occurring ongoing problems dealing with theft of timber, and that issue was trying to be addressed by us, looking at what is the responsibility of the property owner and the responsibility of whatever independent contractor coming in doing the harvesting of timber, and being sure that the lines are correctly marked, etc. We didn't get anywhere with that particular bill at that time, but it's been asked of me to seek to have a House study committee established by resolution to continue the further discussion on this point. And you see from the names at the top, we have a number of people who are involved in the forestry business who serve in the House co-sponsoring this resolution with me. It'll be a one-year service of the committee, and the committee's charge will be to seek recommendations to come back through legislation for the purpose of helping the forest industry with this continuing problem of theft of timber. And is a large industry in our state. As you note in the resolution, it's a $25 billion a year industry. And with the fact that this is having such a strong financial impact, not on our state, but I'm sorry, it's 25 billion impact yet to the state's economy, but also nationally, even larger. And so we want to be sure that there is good legislation for the protection of those who deal with the forestry industry. And I'll be happy to take any questions, Mr. Chairman.
Questions for Chairman Willard. Chairman Weldon.
Thank you, Mr. Chairman. To the chairman of the committee, on line 18, provides that one of the members of the study committee will be from the law enforcement community. I guess I'm just wondering why that is required for this committee, because it's my understanding that generally when timber is taken, it's usually a trespass in a civil context. Or, well, let me restate that. I believe it's more of a civil issue rather than a criminal issue. And I was just wondering if you could comment on that.
It's really both. The question goes to whether there's intent there to steal the timber or whether it's accidental. That's one of the things we try to address. As I mentioned earlier, that study committee was what would be damages. But I think, yes, we do have laws that address theft of timber, and what you unfortunately have with the absentee ownership of large tracts of land that are for timber growth, you may not have someone come visit their property, but every year or more, and so something can happen in a relatively short time of a week or two of a theft of a large quantity of timber, and no one would know about it as far as having been able to observe it happening, and then it's too late. So the purpose of the law enforcement person was just, again, have someone who is familiar with the prosecution of those type cases, helping give advice and guidance.
Thank you, Mr. Chairman. I'd just like to request to be on that study committee.
All right, sir.
Representative Fleming.
Mr. Chairman, I just want to thank you for addressing this. I've had several people in my area come to me and say, isn't there something we can do about some of the timber theft and some of the nefarious operators out there who are stealing, timber and resources and whatnot from folks. And so I just want to say thank you for bringing this forward. I know that there's a need of it because I've had several people contact me about it. Thank you.
Thank you. I think we've got some people connected with the industry might want to comment on.
We've got one over
here. Yeah.
Is Representative Stevenson?
Thank you, Mr. Chair. To the author of the bill, I'm not requesting to be on that committee, but I will say that over the last several years, I can recall many conversations in this room with Representative Black and Buckner regarding this issue. So I think it's time to pull together a committee to work on this issue, because it was criminal, it was civil, and it was criminal. So I thank you for doing that prior to us having another session.
Thank you, ma'am. I might call to all the committee members as well as the public that it says on line 27, members of the committee shall receive no compensation for their services on the committee. Keep that in mind, Mr. Weldon. All right.
I'm already close enough.
Okay.
Anything else from members of the committee? Seeing none, Mr. McWilliams.
Thank you, Mr. Chairman. My name is Steve McWilliams. I'm president of the Georgia Forestry Association, and this has been an issue that a task force of ours has been dealing with for a year and a half, and we feel like this study committee will allow us to take a real comprehensive look at both timber trespass and timber theft. We thank the chairman for agreeing to sponsor the legislation. We look forward to working with the study committee throughout the next year to try to improve the situation in the state. So thank you very much, and thank the committee for hearing the bill.
Questions for Mr. McWilliams? Seeing none, thank you for your presentation. Does anyone else want to be heard on House Resolution 644? Seeing none, we'll go ahead and close off discussion on the resolution. The resolution is now in the hands of the committee. Do you want to say anything more, Mr. Chairman?
No, sir.
All right. Is there a motion?
I move do pass.
There's a motion and a second. Any amendments or discussion? Seeing none, the chair calls the question on the resolution. All those in favor say aye. Aye. All those opposed, no. Resolution moves forward with the do pass recommendation.
Okay. Do we have any senators here for any of the remaining bills that we have? I've got a bill for Senator Stone, Senator Ligon, and Senator Orrock. You want to handle 185 on behalf of Senator Stone? We'll call up Senate Bill 185.
Andy needs to leave, and he's got Senator Orrock's.
Okay. I'll change that. We're going to do Senator Orrock's bill, Senate Bill 158 at this time.
Mr. Chairman,
Yeah, I'm sorry. Excuse me. Yes, sir.
thank you, Mr. Chairman. May I present on behalf of Senator Orrock? She is out of the state at the present time and asked me to sponsor the bill in the House. And may I do some? If it'd be all right, I'll do so from my seat.
Yes, sir.
The Senate Bill 158 is really just a clarification in creating consistency between all of our end-of-life documents that we have that the state has promulgated. And this would strike the word "and" on line 11 and insert the word "or," so it would allow for this to be voluntarily executed, this particular physician order of life-sustaining treatment to be executed voluntarily by the patient or his or her authorized. It previously it said representative, but that term representative is not defined in statute, so we added person as defined in Code Section 31-39(2) in subcommittee. So that provision has been added in subcommittee, and that person is defined by that code section. That person, authorized person, would be a spouse, a guardian of the appointed by court, son or daughter 18 years of older, a parent, a brother or sister 18 years of age or older, or someone that's an agent under a durable power of attorney. So those would be the persons that would be authorized to sign on behalf of the patient. And this creates some consistency between the do not resuscitates and the CPR documents.
Thank you, sir. Any questions of the presenter? Is there anyone else who would like to address the committee? Please come forward. Yes, sir. Have a seat, and we'll get you about one of the mics and let you introduce yourself to the committee.
Hey there. Thank you, Chairman Wheeler and members of the committee. Representative Welch, I think you did a fantastic job describing the intent of the bill. I'm Brandon Reese from Wellstar Health System. We're the largest not-for-profit health system in Georgia. We helped to roll out this statewide form a couple of years ago, and we're very thankful for the legislature in passing a bill that allowed us to do that through the Department of Public Health. This bill does just clarify what we're trying to do. There's been some angst among many of our doctors because of some inconsistencies in the language and their ability to carry out the patient's wishes. And this bill is a simple fix to that, but a very important fix. And I just want to tell you thank you. It's got the support of the GHA, the MAG, the family physician groups, and many other groups.
Good. Thank you, Mr. Reese. I think there's some people who would like to make statements to you. Is that, no? Over here we have the jurors, Mr. Weldon.
Yes, sir.
Okay.
Thank you, Mr. Chairman. Mr. Reese, if this is enacted, this will require the Department of Public Health to prepare a form for a patient who's incapacitated at this time.
Yes, sir.
Someone that they've appointed as defined in OCGA 31-39(2). Correct?
Yes, sir.
Now, so what that does is that puts the authority, the pull the plug or not decision will be made by someone this person is appointed, for example, like a power of attorney type issue, type appointment, correct?
Yes, sir. I think that's accurate. And all that was done in the previous legislation. We're just going back.
This is a living will.
No.
In some ways, it's called a physician's order for life-sustaining treatment. It's a little bit different animal, but there are things that it has in common.
Can you distinguish how this, other than the living will is executed by the person who's now the patient and incapacitated, can you distinguish this physician order that distinguish that from it?
I'm not an attorney, Representative Weldon, but I can tell you that the patient's written a will would trump anything that the physician or any representative would have power to through the polls form.
Just for clarification, we 2006-7 did a way we'll call our living wills. We have what we'll call now a medical directive, which is advanced medical directive, and that may tie in somewhat with this, but this is what the physician has to look to as a means of knowing what life-sustaining treatment they may do. Yes, sir. And
having worked on this issue, essentially, the advanced directive is step one, which is the patient's directive to the doctor. The PULSE is step two, which is the doctor's directive to who may be performing that emergency care on them.
Yeah.
So that for instance, a lot of times these are placed on refrigerators. For instance, and EMTs know to look for it when they go into a house, see whether or not there's one of these out there, to simply just sort of, so that they can see, does this person have any kind of instructions on how I'm supposed to be taking care of them when they come into the house, and that sort of thing. And also, they're obviously also there at nursing homes and in hospitals, so that anyone who comes in has to do emergency heroic care, and will clearly already have the doctor's instructions sitting in the file.
Good. Thank you. Mr. Welch?
No, I wait.
Okay, wait. Anything further, Mr. Welch? Okay, thank you.
Thank you very much.
Thank you too, Mr. Reese. Appreciate you speaking to us. Anyone else wish to address the committee on this legislation? If not, we'll call off further public input, and Senate Bill 158 is now in the rest of the committee. Do we have any discussion among committee members? There being none, the chair will go to the acceptance of motions. Is there a motion on Senate Bill 158? Motion is due pass. Seconded. And I think we do not have this as a committee substitute. This is the bill that came in. It is a substitute. All right. We're looking for then. All right. Always. Motion is due pass on Senate Bill 158 as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you. Senator Liggins. Just in time. We're here on Senate Bill 1, and we have Senator Liggins as the presenter. Thank you for coming.
Thank you, Mr. Chairman. I apologize.
No problem.
Being late.
We're still in business.
We had a bill
still open
that the House sent us that we were dealing with.
Get our House bill out?
It's passed.
Okay. we'll hope to do the same.
Yes.
We'll let you present.
Yes, sir.
Your Senate Bill 1.
Thank you, Mr. Chairman. Thank you. Senate Bill 1 allows well, let me tell you the problem first. There have been instances where you have a custodial parent and where there's been a divorce. The custodial parent does not own the health insurance policy, and so when that parent tries to communicate with the insurer about insurance issues pertaining to the child, that there's difficulty. There's no communication in there, and so then that parent has to go through the non-custodial parent who owns the policy
or the court,
right? Or the court to deal with the issue. And this bill allows the custodial parent to communicate with the insurance company, or if you had a non-custodial parent who's exercising visitation, who likewise does not own the policy, to then communicate with the insurer as well. And of course, it's subject to the court stepping in if it needed to and saying, this is creating an issue. If one of the parents is creating a problem with the insurance company, they could the bill allows the court to prohibit that. So that's the essentially what Senate Bill number 1 does, Mr. Chairman.
All right. Any questions of Senator by members of the committee? I don't see any. I'm going to ask one question. I guess the insurance company, as far as getting proof, they can ask, you know, where's the child's birth certificate, shows you're the parent, whatever.
Yeah.
Some
Yes, sir. And
step-parents.
actually, for the parent to take advantage, they have to provide the insurance company with a copy of the divorce decree or order changing custody that proves that that parent is the custodial parent.
A good, reasonable measure.
Thank you, Mr. Chairman.
It comes up too often, I know from past experience. Do we have anyone further have questions of the senator? If not, is there anyone in the audience who would like to address the committee on Senate Bill 1? Maybe I put my House Bill 1 on Senate Bill 1.
Oh. Had to go down. I like my bill, Mr. Chairman.
Wouldn't that be good? I mean,
they're both
one
number 1
is germane to 1, 1 to 1.
1 to 1, yeah. I think it quickly turned into nothing from nothing leaves nothing.
All right. I thank you.
One can be a lonely number. That's right. One can be a lonely number. That's right.
All right. Very good. Well, we'll keep that in mind later. Is there any further? No one else wishes to address the committee, and we'll close off further public input. The bill is now in the breast of the committee. We have Senate Bill 1. Any discussion among committee members? There being none, the chair will entertain a motion. Motion is due pass. It's seconded. Everybody's supportive of it. Say aye.
Aye. Thank you, Mr. Chairman. Thanks.
Those like sign.
Yes, sir.
All approved. Thank you. 185 is the last one, and I think you, Mr. Jacobs, are all right. Who's going to be presenting for the committee? All right. We'll let, first of all, Mr. Jacobs, you will present House Bill 185.
Thank you, Chairman Willard. Senate Bill 185, every once in a while we have revisions to the Uniform Commercial Code, to the various articles of the Uniform Commercial Code that are proposed by the Uniform Law Commissioners. This is the update to UCC Article 9, the Secured Transactions Code. This is consistent with what the Uniform Law Commissioners put forward, and we have our reigning expert on the UCC with us, so I'll allow him to introduce himself and explain the substance of the bill a little bit, and then we'll answer any questions.
Please do.
Thank you, Mr. Chairman. My name is Anthony Cianciotti. I am here on behalf of the UCC Committee of the State Bar of Georgia. This is one of the legislative bills through the legislative package of the State Bar for this session. Article 9 of the UCC was substantially revised in 2001. This is not by any means a substantial revision. As Representative Jacobs said, in 2010, the National Conference of Uniform Commissioners of State Laws, Uniform Laws, which is the author of the UCC, has proposed some corrective amendments to address issues that have arisen since the substantial revision of Article 9 in 2001. Currently, and I took a little tally just this morning, we now have 31 states that have enacted. That's up from 29 from when this was first introduced in the Senate, and 15 states, in addition to Georgia, have it currently pending in the legislatures. And the reason for that is the National Conference has recommended that all states enact these amendments with a uniform effective date in July 1st of this year, so that the Uniform Commercial Code, at least Article 9, can remain uniform, and that we don't have varying effective dates and differing laws among the various states. To just highlight a few of the changes, and again, these changes have come about because it's a matter of interpreting the provisions since it was enacted. Case law has come out differently in various jurisdictions. A couple of states have actually taken matters in their own hand in the interim period and have enacted state-specific provisions. And so the National Conference thought it was time to come forth with corrective amendments to, again, bring all the states in line. The main focus of the bill is with respect to the debtor's name. For those that have ever seen a UCC financing statement, you list, among other things, the name of the debtor, and that is critical in terms of taking a lien that you have and perfecting it under the law so that you are in first position with respect to that particular asset. Well, there's been, over the years, there's been some discussion, particularly as it relates to individual debtors, as to how you properly identify the debtor's name. And with these amendments, they would provide that if the individual has a driver's license that's valid and is issued by the state of Georgia, that will be the document to which you will refer when trying to determine the person's name. There's also some changes with respect, and that in fact is consistent with how we operate currently when it relates to organized entities such as corporations. We can look at a specific document, that being the articles of incorporation of the entity. So now with respect to an individual debtor, we can look at a specific document. Other changes have to do with plugging a hole in the law regarding security interests when a debtor might change its location, so an individual that might move from one state to or another, or when you have a merger of organized entities and how one continues their perfected security interest, not only in the assets that exist at the date of the event, either the moving of location or the merger, but also assets that are acquired after that happens. And there is currently a hole in the law which was recognized, and to solve that. An additional change has to do with the filing of a mortgage to serve as not only a lien on the real property, but also as a fixture filing against any personal property that might be attached to the premises. Georgia law is currently not uniform, and it currently requires that you file both a mortgage and a UCC financing statement. And it is my understanding that came about because when we revised Article 9 in 2001, we were concerned because we went to a central index filing system, and there was a concern that when filing UCCs you might have to file in different places to have a to have a lien in both the real property and the fixtures attached as personal property. We've seen in practice since the enactment of revised Article 9 in 2001 that you file in the same place, the county in which the real property is located. So given that we've seen that operate in practice, the UCC Committee of the State Bar, in putting forth these amendments, decided it would make good sense to bring our law here in Georgia in line with the law of other jurisdictions. There are benefits to a creditor in that instance because a fixture filing that's in the form of a financing statement needs to be continued every 5 years. It requires a ongoing maintenance, when if the mortgage can serve that function, the mortgage remains effective until it's released. So again, this is to bring us in line with the law in other jurisdictions and provides an ease of administration for loans. And then lastly, I'd just like to mention something called an information statement. It's currently called a correction statement under the law. And when we went to the current format under Article 9, we removed the requirement that a debtor have to sign a financing statement. So basically anybody can file a financing statement, and that's made the process easier, but at times individuals who are not authorized to file financing statements in fact do so, and apparently that's fairly common with public figures. They'll just claim a lien, and the current law allows the individual or the entity against which it's been filed to file something in the record that says this was not authorized, and basically invites future creditors that might be seeking to lend money to go behind that what seems to be a lien against the property and inquire. The changes in the law would allow a similar type statement to be filed not only by a debtor, but because you can also terminate a financing statement without having it signed. And so there, as we've realized under the law, you have instances in where someone may incorrectly and without authorization either amend or terminate a financing statement. And so this now allows the secured party, to the extent they didn't do it themselves, but someone else without their authority did it, to file this information statement to point out to future secured parties or potential secured parties that in fact that should not have been filed, that the underlying lien is still valid, and that the financing statement that was filed is still valid. So again, just to summarize, these are all changes that are more surgical in nature, not looking to undo, but basically bring forward, consistent with the laws and most other right now jurisdictions, and hopefully in the short term all jurisdictions, so that Georgia law is consistent, and then we have a uniform law with the other states.
Is it Cincinnati?
Cincinnati. It was very close. Well done. It's.
Thank you for that riveting presentation.
Well, I figured if I spoke enough, then I would eliminate the possibility of any questions. So.
You're not that lucky.
Okay.
I'll get the presenter now to ask you a question.
Close, but no cigar,
Okay.
Mr. Cincinnati. Section 10 of the bill, and this was a question that the chairman posed to me as well. Generally speaking, in Georgia, we use deeds to secure debt instead of mortgages per se. Now, I note that in the existing Article 9 language, we do use the term mortgage. Is there a need to change that in
Section 10?
Well,
Section 10 of the bill, starting on line 209?
Just give me 1 second here. No, and the reason no is that if you look at, well, this is not something that's being amended, but if you look in Article 9 as it currently exists, the definition of mortgage is defined broadly to mean a consensual interest in real property, and then also says the term includes a deed to secure debt.
Thank you. Good answer.
And I think, Mr. Lindsay, you have a question.
No, just a brief comment. I
Okay.
just found it interesting that the chairman of this committee should question how long Mr. Cianciati spoke on the bill.
I don't either. We're pleased to have you here today, regardless.
My pleasure.
Actually, it was an excellent presentation.
Thank you.
We had somebody else wanting to talk, I believe. There's somebody else? No, that was the only one on that. Excuse me. I look at 158, a little transposition there. All right. Is there anyone else who would like to continue this wonderful
riveting
discussion? If not, we will close all further public comment. The bill 185, Senate Bill 185, is now in the breast of the committee. Is there any discussion? If there is no further discussion, the chair will entertain motions. The motion is due pass, and there's been a second to that motion. Any further discussion on the motion? Are there any amendments? No amendments. The chair will call for the main question, which is due pass, Senate Bill 185. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. We thank you for being with us.
Thank you.
I think I did a great job.
You carry it? Oh, gosh. Oh, we are now stand adjourned. Yes, we will now stand adjourned. That was the last piece of business for the day.